Thank you, Mr. Speaker. Members, I think we are, I've had the great joy over the last 5 months of having an opportunity to work with Speaker Moody for dozens and dozens of hours on bail reform. Most things we have agreed upon. And I understand him and know him to be a moral and honorable man. Truly. The concern that I have that we pass this SJR is that if we do not pass it, we will not be able to properly constrain judges who would release certain very dangerous people onto the streets of our cities, our towns, and our counties in the state of Texas. That is the moral conundrum we are in. Are we willing to let the law remain unchanged and put more people at risk because they are at risk? One of the murders that was alleged that I mentioned earlier, one of those murderers who's been alleged in Harris County was released on $75,000 bond. They wrote a $7,500 check and they walked out of jail to commit another offense.
Mr. Speaker.
Romero, for what purpose?
Does the gentleman yield for questions?
The gentleman yield for questions?
I certainly do.
He yields for questions.
Thank you, Representative Little. I appreciate your passion. I think everybody does. And no one wants to see someone that's, find themselves in a situation where this young lady lost her life or be a parent to that child. In that situation that you described, was that original offense that was committed, was that one of the Abbott 9 that you described?
A murder, yes.
So that person murdered someone and got out on 75?
Was alleged to have, I think is the proper way to say that.
So the person was out on bail. Okay, so to Speaker Moody's point, I just want to clarify a couple of things that were said. So there will be no more judicial discretion on these Abbott 9, no opportunity for electronic monitoring, pardon me. So they are required to jail people without bond, correct?
On these 9 offenses for whom there is either a conviction or they are already on bail for one of those same offenses.
Okay. So could you see a scenario where your proposal could have someone held pre-trial for months or years based on probable cause alone, even if the judge was convinced that the person was not a threat?
No.
So because you don't see the judge ever seeing that person is not a threat after this proposal, if it were to pass?
Not after we have a known conviction or already having bailed the same person for the same alleged conduct in a separate violent incident.
So isn't the case that if SJR 87 passes, this bill will be the first time in Texas history that our Constitution would require taking away someone's liberty without allowing a judge to consider the individual facts of the circumstances of this case?
No, the answer is in our Constitution, we already have the ability, the judge already has the ability to deny bail on probable cause on capital murder. So we've confined or cabined that particular offense to permissive bail denial.
Okay. So they would not have to prove that detention is necessary under your law?
That what is necessary, I'm sorry?
The detention is necessary.
Correct.
Under 87, is there any requirement that a judge first consider alternatives to detention?
No.
After probable cause determination, what opportunity does 87 provide for defensive counsel to contest detention, cross-examine witnesses, or present mitigating evidence?
They will not be able to, and I want to circle back to the situation with this deputy constable who was assassinated in Houston, particularly. When those gentlemen came back and they were alleged to have committed a second murder, the defense decided to essentially waive bail, knowing that the community itself was incensed about their having been released the first time. So I think on the part of some defense counsel, they know intuitively what we're dealing with in this chamber this morning, that the community is rightly outraged at people who are released on bail for violent offenses and for whom new violent offenses are alleged.
I know that you point to that one that one case.
Sure.
How many other cases could there be that someone is now going to be denied bail? A U.S. citizen is going to be denied bail, but we use this one case, and now how many hundreds, maybe 10, maybe hundreds, maybe thousands of people will now be denied bail. And I think that goes back to Speaker Moody's point that for the first time, you have folks that are being denied bail without having to prove that they are a flight risk, that they are a threat to society. Let me ask you this question. So how does this proposal align with the procedures and safeguards in the Federal Bail Reform Act, which requires individualized risk findings and adversarial hearings before pretrial detention is authorized?
I'm glad you asked that question. So under the Bail Reform Act of 1984, the federal government similarly has the ability to deny bail. And so bail is not guaranteed under the Bail Reform Act of 1984, and the judge does have discretion to deny bail completely. It's why we use that, and in my amendment to SJR 5, we use that as a model for the evidentiary standard of denial of bail. The step that we're taking here is to take the discretion away from the judge to say, these are the most high probability violent offenders in our state, and OCA captured about 2,000 of them over the last 2 years that could be denied bail under a repeat offense.
Okay. If a court were to invalidate SJR 87 on constitutional grounds,
Yes, sir.
what safeguards are in place to redress the detention of individuals held under its authority during that period?
I'm not sure I fully understand your question. I believe, let me try to answer it. If this were found to, on a federal level through a district court lawsuit to be unconstitutional, I would expect to see an injunction. Normally when we have laws in this chamber that are made and someone believes they're unconstitutional and there's a federal lawsuit challenge, there's typically an injunction that goes along that. So I would expect there would be some type of injunctive relief staying the application of SJR 87.
Okay. Does your bill have any safeguards for if one of those Abbott 9 were committed when someone was 14, 15 years old, when they were a teenager?
It does not make a distinction as to the level of conviction. So let me just take your hypothetical. If we had a 14 or 15-year-old who committed murder and had a previous conviction and was paroled.
Let's say it was one of the lesser, and they got in a fight.
We want to choose one of those?
Yeah, let's use that, because the reason, and I'll extend on the question. There's a teenager.
Yes, sir.
Grows up in a part of Texas that isn't the safest neighborhood. Maybe he was defending himself, but at that time that judge didn't have enough evidence to prove that it was self-defense and someone was harmed. 20 years later, maybe 30 years later, is now accused but not guilty. That young man or woman would be held without bail indefinitely. So I'm asking you, did you put any protections against a crime that might have been committed, one by a teenager, and even further, 20 years later, any time period whatsoever?
There's no distinction as to the age of the offense in the resolution.
Could you understand how we have laws on the books today where someone maybe actually never committed a crime? Say, for example, the law of parties. You were a party simply because you were in the vehicle. You had no idea what was going on in the convenience store when somebody went to rob. That happened as a teenager. You're not responsible. And then later in life, 20 years later, do you not feel like that is an injustice, a violation of our constitutional rights, that someone is now being held without bail for something that they actually never committed the act?
It's an interesting conversation, and I'll say that the law of parties does not relieve them of criminal responsibility, nor is that a thing that we are able to say about that person. If under the law of parties they are convicted of, for example, aggravated robbery or felony murder as an example, we don't make a distinction as to whether they were the getaway driver or participated in the crime or pulled the trigger themselves. So I will just say that there is not a distinction there, and that once that conviction has occurred, everyone's on notice that if there's another commission of one of these most violent or heinous offenses, they will be denied bail.
Do you believe that person is guilty of murder if they had no idea, and even if the person that actually did commit or pulled the trigger said that person was not responsible?
I think there are endless permutations of that same fact pattern that I've seen, and there are various grades.
Gentleman's time has expired.
Thank you.